A juicy new update in the warrantless home invasion case from victim Natasha Lopez down in Cherokee County, Georgia. A quick clarification on the judge in the Memphis thug cop case. A mental state clarification in the Psycho Baltimore cop case. And a wild good cop of the week. All on this week's episode of The Rebuttal. What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer, and this is The Rebuttal. This is a weekly show that we do where we basically talk about some of the cases we've talked about in the past, and sometimes I'll do like clarifications for things that come up in the comments that maybe I didn't think about clarifying or explaining better when we did the video. And this has become the new home for a segment that the audience has requested called Good Cop of the Week, just to sort of sprinkle in a little bit of hope in upside down world on a weekly basis. Just as a reminder, anything that I talk about in this video, if you're not familiar with it, you can pause the video, go to the description. There will be a link to the original video and the coverage so that you can get caught up to speed, and then you can come back and catch up on context. First item on our docket for the day is just a teaser for a long form video that's going to come later in the week about the case of the warrantless home invasion down in Woodstock, Georgia, Cherokee County. Now, you guys have seen the original video that I posted, which has several 100,000 views. You guys have seen Natasha Lopez's long-form interview with me telling the entire story. But now, interestingly, because you guys helped raise an incredible amount of money, she was able to hire a criminal defense attorney because of your all's generosity. And now it looks like her case is not even going to go before the grand jury or be officially charged because they realize they have screwed up. So you guys have seen her on my channel, and then John Bryan, of course, picked it up, and that's where most of the traction has come from. I certainly take no credit for it. John has had 1.8 million views on his video to date, and so obviously that's where most of the traction's coming from. But what Natasha has given me this last week is something that we all know happens, but it will blow your mind. You're going to get a firsthand backstage pass to see how one of these handshake internal affairs investigations actually plays out. Now, remember that Natasha did all of the things, right? She filed a complaint with the Post. She has filed with the Attorney General in Georgia. She filed with the police department. And now she's trying to get her criminal charges dealt with so that she can file a lawsuit. But interestingly, there's a statute of limitations on filing a civil suit. And I think she told me that according to her attorney or somebody that she's talked to there, the state of Georgia has like 2 years to deal with that. But the good news is she has been in contact with the Institute for Justice. I believe that's because of the connection that John Bryan has with them, but I'm not sure. This is just me speculating. Nobody's told me that. This is my assumption. I reached out to the Institute for Justice, but I don't have a relationship with them, and I didn't hear anything back from them. So I'm assuming that she's had a conversation with IJ because of the fact that John did the story. But here's the cool part. They have provided to her through records requests the actual audio of the interview from this absolute clown, Lieutenant Barone, who is allegedly leading the Internal Affairs Division. Guys, I'm going to do a video later in the week, and it's just going to be me playing this Internal Affairs audio for you guys to hear. It is exactly what you would think it is, only worse. Literally, he is coached, his hand is held, he is fed answers, and it's literally like a buddy of his. They're having a brainstorming session about how to answer the questions if asked by Internal Affairs. It looks nothing like a legitimate Internal Affairs investigation. So I'm going to do a video later on the week in that, breaking the whole thing down. You guys are going to love it and hate it at the same time, because you're going to love the fact that it gets exposed, but you're going to hate the fact that it's a reality. But the good thing is that you can match it right up against this idiotic letter that he sent out saying that, you know, we investigated ourselves and found no wrongdoing. Well, you can find anything you're looking for when it comes to an internal affairs investigation. And if all you're looking for is a reason to sign off on it, which is obviously what they were looking for, you can find it, especially if you don't ask any tough questions. So watch for that video. That's going to be coming up later in the week. Second item on the docket for the day is a clarification on the judge's powers in the Memphis thug cop case that we covered last week as an update. It involved defendant Mario Shaw, who basically had a beatdown from two police officers because he wouldn't bend the knee and kiss the ring. That's really what it was all about. The cops came to talk to his neighbor because they'd had a dispute over somebody's dog using the bathroom in one of their yards. It was like a stupid Karen and Darren neighborly dispute that really did not warrant Memphis police presence, given the fact that Memphis has got a lot of shit going on, and whose dog is shitting in whose yard really isn't sort of like at the top of the priority list, or shouldn't be anyway. But hey, maybe that's the reason Memphis is a shithole. Anyway, because he didn't do what the cop asked him to do and didn't want to identify him, the cop basically just ran at him, just charged him, and they got in a fight, right? And actually, Mario got the best of him, I would argue. But the cop ended up biting him. It was disgusting. It was as disgusting, one of the worst police interactions where somebody actually survived that you'll ever see. But when I played the video, a lot of people were praising the judge because the judge dismissed it. He called the cop out on the stand. He essentially said, look, the video contradicts your testimony. Some people in the audience basically were really disappointed and called for the judge to have something done to him because the judge did not charge this officer with perjury. And so it made it obvious to me that maybe there are some members in the audience who really don't understand, I guess, the essential roles or functions of a judge, or maybe any party of the criminal justice system. So I wanted to take the opportunity to sort of explain how this works, okay? And some of this might seem a little bit elementary, so, don't take it personally. If you know, you know. But there are a lot of people who clearly don't understand how this works, and that's why I got so many comments about the judge charging the cop with perjury. Police officers investigate, right? We know that from every single video we've ever seen. Although they don't know what an investigation is, that's not the point. The point is, the job of a police officer is to investigate to determine whether probable cause exists to charge a person with a crime. And then they introduce that person through their warrant affidavit or whatever document they attach to this circumstance where they believe they have probable cause. They introduce that person to the criminal justice system through that document and through the arrest paperwork. They then become nothing more than a witness for the state, okay? Then the prosecutor takes that information and says, yes, I'm going to formally charge this person, or no, I'm not. A police officer cannot actually charge someone with a crime. A police officer does nothing except introduce this person to the criminal justice system and essentially formally ask a prosecutor to review the case for charges. That's essentially what an arrest does. The prosecutor can at any point say, I don't see it, and dismiss it, and there's no more arrest, there's no more prosecution, there's nothing else. A judge is neutral and detached. The judge does not have the ability to charge anyone with any crime. And you wouldn't want them to be able to do that, right? And so I understand the sentiment. A lot of my audience dislikes cops, dislikes prosecutors, dislikes judges, and a lot of that is for very good reason. I get it. But the thing is, if the judge had charged this person with perjury, the judge doesn't have the authority to charge a person with perjury, for one. And so if the judge did that, the judge would be overreaching his authority or her authority and enforcing feelings instead of law. And we can't have that. That's the problem with the system now, right? We don't want the judge, even if it's somebody we dislike, to overstep their authority and weaponize their power because of their personal feelings. The whole point, the whole reason we're in the situation we're in, is because of people doing that through the filter of the police first and then the prosecutor first. And then we put it in front of the judge. The judge is supposed to be the one that looks at the case and says, okay, feelings aside, this is what we have to do. So that's one thing to consider. A lot of the audience wanted the officer charged with perjury. But in addition to that, they wanted the judge to put the person on the Brady list. The judge also doesn't have the authority to do that. The judge can essentially say, I find this person's testimony to not be credible, but it only relates to this particular matter. He's only presiding over this one case. He can't just say, this officer is not credible forever, he's a liar. He can't do that. The judge doesn't have the authority to do that. The judge is duty bound to examine the case that's in front of him and the testimony being offered. Because again, remember, I told you that once the police officer introduces the defendant to the criminal justice system, the police officer is rendered as nothing more than a complaining witness. All the judge can do is determine whether this witness is credible. The judge can't say, you're not ever credible, you need to be added to the Brady list, none of that. That is not within the judge's purview. The judge can't ban him from testifying in future cases. The judge can't label him Brady list Giglio. The judge can't make a declaration that he's, publicly that he's not credible, any of that stuff. He can't do any of that. And he can't sanction the cop on behalf of the court. The judge can charge contempt, but only under certain circumstances. And then if the judge commented too strongly, like if he accused the officer of perjury, If he had said, I'm going to have you charged with perjury, now the judge has rendered himself a material witness in a potential prosecution for perjury, and now he has to recuse from the case altogether, and he's a witness and not a judge. So there's a bunch of reasons why you would never want the judge to do this, even though we might like to see it play out in front of us because we don't like the cop because he's a douchebag, right? Still, today it's the cop. Next week it's us, okay? We have to remember the slippery slope of enforcing feelings over law. And it's not one of those situations where we can be okay with it today because we don't like the guy, because it's going to bite us in the ass when it's our turn. That's the whole value of the slippery slope argument when it comes to basically anything. And the follow-up thing was, well, he can charge him with contempt. Lying in court is contempt. It's not. Contempt is disrupting proceedings, disobedience of the court's order, or misbehavior in the court's presence. Lying under oath does not disrupt the proceedings. It isn't a violation of the court's order, and it is not misbehavior in the court's presence. It is perjury, okay? It's perjury. It's not contempt. Perjury requires prosecutorial action. And that leads me to the actual issue, which is that we have to remember that there is a thing called separation of powers. And I realize that it's hard to remember that, or easy to forget, or however you want to look at it, because we're always like, well, yeah, the separation of powers and checks and balances and all that stuff only works against us. It doesn't help us. But the truth is, it does help us. A police officer and a prosecutor are members of the executive branch, okay, of any government. Judge is a member of the judicial branch. They're supposed to be neutral and detached. They're supposed to determine the issues within the case in front of them. They do not have any statutory power, any lawful authority to be charging anybody with anything. Their job is to interpret the cases as they come through and make rulings about the matters that are before them. And that's it. The figurehead of the executive branch is the governor, and he has the ability to direct his top law enforcement officer, typically the attorney general, to do executive functions, okay? The chief justice or the head justice in the state Supreme Court is the head of the judicial branch, okay? They make the rules as it relates to all of the courts and all that stuff. And then you obviously have your legislators and the, leader of the Senate and a leader of the House of Representatives or whatever. These people are part of the legislative branch. So if you want the law changed, legislative. If you want the law enforced, executive. And if you want cases decided and interpreted, judicial. That's what the separation of powers was supposed to be all about. And I realize they only do a good job when it suits them, but that's not the point. We can't be making calls for these people to overstep their authority and cross into each other's paths, because it's not good in the end for any of us. Because, again, this week it's the cop, next week it's us. Keep that in mind. So, on to the third item on our docket for this week, and that is a quick clarification on mental state as it relates to the case of the Psyho Baltimore cop who tried to run over the misdemeanor arrestee with his vehicle. I said in the video, as we broke down, that they've charged this police officer, Robert Parks, with attempted second-degree murder, and they've charged him with misconduct in office. And I explained why you would never get a conviction probably under attempted second-degree murder. And I said that that's because the law requires specific intent. There are several intent standards. There is, intentionally, knowingly, all of that is like a general intent. So an example of that would be this officer knew this person was in front of him, and he intentionally and knowingly ran his patrol car towards the guy and attempted to run him over. And my audience responded and said, well, I think we can infer his specific intent from the fact that he ran him over. No, you can't, because specific intent is anchored to the desired outcome of it's not the what, it's the why, okay? The why is the thing that is the motive, right? That's what the motive means in a criminal case. But in order to prove specific intent, we have to know why. And the only way we get to attempted murder and get a conviction for it is if we can prove that the officer desired the specific outcome of ending his life. The general intent is satisfied by why. It's obvious he knew what he was doing. He chased the guy through the field. That's not enough. The law does not allow willing, intentional. It's specific intent. You have to prove that he was trying to kill him and failed to do so. That's what attempted murder is. And then we went on to the assault standard. The assault standard for assault in the first degree requires the specific intent that the officer is trying to cause serious physical injury. Well, again, this officer could easily say, I was trying to arrest him for the warrant. I was trying to use my vehicle to get him to stop. I thought I could do that. Unless we have some evidence that his actual intent was to cause serious physical injury. Not that he didn't care, because that's a depraved heart or a recklessness standard. It's not specifically that what I was trying to do was cause serious physical injury. That is specific intent. So just separate these things in your mind. General intent is about what happened and that it happened. Your general intent, I'm going to intend to take a drink of this Coke Zero. That's my general intent. My specific intent is because I'm thirsty and I want it to quench my thirst. But if you have no way of knowing that unless I tell you, I could very easily have the specific intent that I have too much Coca-Cola in my house and I just want to make this disappear. Okay? If I poured it out, the general intent would say he just dumped that can of Coke on the ground. But my specific intent might be that I'm sick at my stomach, so now I don't want to drink this anymore. Or I don't like the way it makes me feel, or I've had too much caffeine today, or I just don't like the color of this can, so I've decided it's not for me. Maybe I decided to be a Yankee and fall in love with Pepsi this week. The point is, the why is specific intent. And there's all kinds of different theories as to why he could have hit this guy. None of them good, but unless we have evidence that it's this one specific thing, you can't prove the crime. That's the way the law works. Examples of specific intent crime are assault and burglary, right? At common law, assault is my specific intent that I want to create a reaction in this person. That's why it's a desired outcome. In a burglary, the traditional common law elements of burglary were to enter the property of another at night with the intent to commit a felony inside. That one right there. The intent must be to commit a felony inside. If I enter the property of another person and I do so at night, but I do so because I'm homeless and it's cold outside and I want to get warm, I have not committed the crime of burglary. I have committed the crime of trespass. So that's why general intent will not work for these convictions. Misconduct in office requires specific intent too, but it's a specific intent that looks more like general intent because the only specific intent you have to prove is that he specifically intended to exceed his authority. And anybody knows that you can't run down a misdemeanor warrant guy with your car. So he had to make a intentional decision to specifically step outside of the bounds of what he was lawfully allowed to do. And that's a much easier case to prove. And that's the reason that if he's convicted of anything, it will likely be misconduct in office and none of the other things. So hopefully that clears it up as far as specific intent versus general intent. Remember, general intent is the what. Specific intent is the why. It's a desired outcome most of the time. And on to the final matter for the week, and that is this wild video of this good cop of the week. The only thing I know about this officer is that he's from Fairfield Heights, Illinois, but I'm not even going to tell you anything about this case. I'm just going to let you watch the video, and then we'll come back and talk about why this guy is good cop of the week.
Fairview 187. My vehicle's just been hit. Started an ambulance.
Hey, what happened?
You tell me!
I need a new car.
Somebody ran into me, pushed my vehicle into the other vehicle, started an ambulance, need a supervisor. Here, come over here, buddy. Get out of the road. Here, have a seat real quick. Have a seat. You all right?
Yeah, I'm all right.
What happened, dude?
I don't know, man. I've been drinking.
You been drinking?
Yeah, I've been drinking.
Okay.
And I took some weed pills.
Some weed pills?
Yeah.
Okay. Anybody else in the car?
Nah, it's just me.
187. Started trooper. Here, just sit down, man. Just sit down.
All right.
Driver tells me he's been drinking and took some weed pills.
Here, let me get
No.
my phone.
Sit down, sit down.
Okay.
I don't want you to get hit, okay? Hey, you guys all right up in there? All right, just hang tight, okay?
Can I stand up? My head's getting like.
Just sit down, man. You just in a bad accident. I don't want you to get hurt. Okay? You wandering around out in that traffic, somebody gonna hit you.
Somebody gonna hit me. I got insurance. It ain't gonna cover that though.
Well, I don't know, but that's not what we're concerned about right now. We're concerned about everybody's okay, all right?
All right. I did that on purpose, sir.
What, you hit me on purpose?
Yeah, I did.
Why is that?
I'm bored.
You bored?
I'm bored.
So you ran in the back of me on purpose?
Yep.
Why is that?
I hate cops, man.
Yeah? All right. We got an ambulance coming, okay?
All right.
All right.
They gonna take me home or I'm going?
I don't know. You ain't got no weapons on you, do you?
No, sir.
All right. Go ahead and put your hand down your back for me.
All right. So am I going in the ambulance?
They're going to come and check you out, okay, partner?
Okay.
All right.
You put my wallet back in my pocket?
Yeah.
Okay, so this officer is trying to conduct a traffic stop, and he's approaching from the passenger side and away from the traffic, right? And this person, Mr. Jennings, crashes into the back of this officer's police cruiser. And just as a little side note, that right there, that dynamic right there is exactly how we got Pennsylvania versus Mims, because the officer in Mims said that he asks every driver that he talks to get out of the car and talk to him over on this side of the road to avoid being struck by a car on that. That's why the court said, okay, as a precaution for officer safety, it's okay if you have this person stand on the side of the road and have this conversation with you, as opposed to just sitting in the car. And don't get it twisted. In Mims, the court did not and has not since limited to, specific officer safety concerns. It's a general prophylactic approach to officer safety. That's the reason that we've gotten this carte blanche situation. But anyway, that's kind of an aside. This cop was completely calm. I've never seen a more calm police officer in my life. The guy says, "What happened?" And he goes, "You tell me." And then he's sitting there. He's not going crazy on the guy. "Oh, you tried to kill me." He didn't beat his ass. He didn't do anything. He tells the guy to have a seat, but not like, "Get down on the ground, you piece of trash." Nothing like that. It's, "Hey man, have a seat. Are you okay? Whatever, we'll call an ambulance, get you checked out." The guy tries to get up a couple times and he's like, "Hey, just have a seat, just chill out, man." And then the guy says, "I did this on purpose." And he cuffed him up. No roughing him up, no using force, no beating him, no cussing him, no losing his temper, nothing. Just a complete lack of egotistical approach to this arrest. Now, as it relates to the admissibility of the statements, because he put him in handcuffs after the guy told him, "I did that on purpose," now he's going to have to issue a Miranda warning before he can ask him any questions, because now the guy is in cuffs, he's in custody. So if the officer is going to interrogate him about it, then he has to read him Miranda rights. But a common misconception is that anytime you get arrested, you have to be read your Miranda rights. But here's a perfect example, a perfect case during our Good Cop of the Week segment where I can explain to you why this guy does not need a Miranda warning, okay? This officer has no questions that he needs to ask this guy, unless he wants to charge him with DUI. They've charged him with aggravated assault, which is a more serious crime than DUI. If he wants to charge him with DUI, he's going to have an uphill climb to actually prove this case, because he has no evidence of intoxication. All he has is he was looking this way, somebody hit his car, no evidence of intoxication whatsoever, okay? So, and he can't get that without reading the guy the Miranda rights, and now he's in cuffs, so he can't do field sobriety tests. But he could read Miranda rights, and the guy could agree, and they could still get a DUI case out of that. But the aggravated assault is complete. The officer observed his car be struck. The guy walks up and says, "What happened?" The officer says, "Well, you tell me." He's not in custody. He's not entitled to a Miranda warning. The officer doesn't even know that he's looking at a criminally suspicious person at this point. The guy says, "I did it on purpose." That is an excited utterance by definition. And so that is a mental state statement that did not come as a result of the officer asking him questions improperly or anything like that. So he could take this guy to jail, and as long as he doesn't intend to charge him with DUI, his investigation is complete. He saw it. The guy, on his own volition, said, "I did this to you on purpose." And he says, why? He's not in custody. He says, "Because I hate cops." The case is closed. It's proven. Aggravated assault. I intentionally did this because I hate cops. Boom. There you go. You got your why, you got your what. And all of this flows very nicely into our previous discussion on mental states. Anyway, that's the good cop of the week. Unknown, unnamed officer from Fairfield Heights, Illinois. Good job, sir, on keeping your cool when you were almost ran off the road by a person who hates cops and wanted to kill you. I do not know how you're going to contain the amount of popularity, excitement, and, let's be honest, attention from women that you're going to get now that you are good cop of the week from Southern Draw Law. But anyway, that's all for this episode. We packed a lot of stuff into this episode. Hopefully you guys got a lot out of it. I'd like to invite you to check us out on the socials. You can use your camera to scan the QR code that I put up on the screen. That will take you to the Linktree site where you can check out the YouTube, the Facebook, the Substack, the TikTok. You can join on a paid tier of Substack if you want to, but that's only for people who want to support the channel monetarily. I don't put anything on these platforms that people have to pay for. If you don't want to follow us to another platform, but you'd like to support monetarily, I'll put my Venmo and PayPal links both here on the screen as well as in the description. Please remember to like and subscribe and leave a comment on the video. Check out some of the other videos on the channel and leave a comment on there as well. Until I see you again, take care. Always film your interactions with the police and keep your evidence to yourself.